He missed court, claimed his wife was dying in Mexico, and now faces a $30,000 bond. Was it compassion or consequence? Watch the video to the end to know every details.
And it was on the Mexican side. They all live in Laredo. But now he will have a phone. Now he will have a place to stay. Now they lost. They had a very tragic incident with a new wife.
All right, we're going to go on the record. The court is calling 2025 CR 007972, State versus Jesus Enrique Alexander Velasquez. Could I have the parties announce?
Attorney for the state of Texas.
Thomas Taylor, ready?
And are you Mr. Velasquez?
Sí.
Yes.
All right, we're here for our motion to set bond. And it appears that the state has agreed on a bond of $10,000. Is that correct?
Yes, Your Honor.
All right. And what is Mr. Velasquez's criminal history? I'm assuming since he's charged with continuous violence against family, there's a previous assault case.
This is tomorrow.
Excuse me. You all can't do the side chatter because the court reporter is taking down everything that everyone is saying. And I'm sorry, could I have the interpreter, if you could raise your right hand for me, please? Do you solemnly swear and affirm you will faithfully translate from English into Spanish and Spanish into English, so help you God?
I do, Your Honor.
All right, you can lower your hand. If you'll state your name for the record.
My name is Catalina Delgado, Delgado, license number 2222.
All right, and state.
So he had a previous assault yet in April 11th, 2024, that became part of his current continuous violence case against the family. Otherwise, he doesn't have.
And the previous assault, is that the same complainant? All right. Mr. Velasquez, can you raise your right hand for me, please? Do you solemnly swear or affirm the testimony you give will be the truth and nothing but the truth, so help you God?
It's huge.
Yes.
All right, so here's the thing. Either you're going to speak in Spanish or you're not.
Habla español.
Hablo español. Yes, sí, ma'am.
I'll speak Spanish, yes, now.
All right. And the reason why I say that is because we have an interpreter here. All right. Have you ever had any type of mental health diagnosis?
I'm sorry, what did you say?
Have you ever had any type of mental health diagnosis?
No, ma'am.
Have you
No,
ever
ma'am.
been, thank you. Have you ever, yeah, I guess we're going to speak in English and in Spanish. Have you ever received any type of medication for any type of mental health treatment?
No, pues.
No, Judge.
Have, in the past, have you ever used any type of drugs?
No, pues.
No, Judge.
All right. This is what the court is going to do. What is his current bond set at? Counsel, what is his current?
The clerk says there's no bond at this time now.
There's no bond that's been set?
It was originally 10,000. He used the court date and he was remanded without something.
All right. So we have someone who's missed a court date. Counsel, why did he miss his court date?
Respectfully, at the time, his new wife was in the hospital and he had to pawn his phone at the time because he had no money and he had to come up with 40,000 pesos. And it was on the Mexican side. They all live in Laredo. But now he will have a phone. Now he will have a place to stay. Now they lost. They had a very tragic incident with a new wife. And at this point, Your Honor, he's no longer with the victim of this in this case. At this point, Your Honor.
Well, here's my question. The wife that he was helping in Mexico, is that the same wife who's the complainant?
No, Your Honor, it's different. It's a new one.
So this new alleged person, is that his girlfriend? Why
Yes.
he has, so he has a
She's on Zoom as well.
so he has a girlfriend in San Antonio.
No.
It's in Laredo.
No.
Well, this wife that you're saying that he had to get money for,
No, this is a new wife.
and is this new wife somebody other than the complainant in this motion?
Yes, Your Honor.
So he has somebody in the complainant in the motion. Is this complainant in the motion his girlfriend?
No longer together, Your Honor. No longer together.
And you say there's someone on Zoom who wants,
Yes, she's going to be the new wife that he had to sell his phone to be able to pay for a medical emergency. And I can call as a witness if she should be on Zoom.
Oh, she is. Could you unmute, please? And show video. All right, so the fact that while she's waiting to unmute, so the fact that he had to sell his phone, that still doesn't explain why he was not in court.
He didn't have a way to get notification about the court date. He did not know. But now he understands how important it is to make his court appearances in the future.
So how long has he been in custody?
2 meses y
2
una
months,
semana.
2 months and
2 months and 2 weeks.
So the warrant for his arrest was issued in July.
He may have some time from before.
No. I mean, I'm saying he was issued in July. So is he saying he's been in custody since July?
No, es porque en junio fue cuando empeñé el celular.
No, because in June, that's when I pawned my cell phone.
O sea, no tenía forma de saber cuándo tenía la corte.
I had no way of knowing when my hearing was going to be.
Y no tenía trabajo tampoco.
And I also didn't have a job
Porque me despidieron por haberme movido a México por la emergencia médica que tuvo mi esposo.
because I was fired since I had to move to Mexico for the medical emergency my wife had.
No, when you are given when you have a charge, you're given a court date before you're released. Wasn't he arrested for this offense? If he was arrested for this offense and it was not at large, he would have had a court date when he was released from the jail. That's my question, counsel.
¿Cuál es la pregunta? No, estuve cuando yo salí la primera vez, estuve preguntando.
When he first got out, he was asking.
But no.
Okay.
So here's the thing. If he's talking, I need the interpreter to interpret.
Cuando salí la primera vez, los primeros meses estuve preguntando diariamente sobre la corte y ellos me dijeron que dejara de hablar porque ellos me iban a avisar.
When I first got out, I kept asking. I asked for about a month and they told me to stop calling, that they would let me know.
He was calling daily also.
He was calling daily.
So
I mean, well, that's what he's saying. Where's the proof that he pawned his phone and he paid a medical bill? Do you have that?
Yes, Your Honor. I have.
Yes.
I just got email from the wife. Me
You need to show it to
the
the state.
And this is why you had to sell his phone. Yes, have you seen the good phone? I want to be full.
I apologize. I just got email. So I talked to. And let me just show you how that works. This is for the phone. If you close it, you see the hospital bill in the same email. On the right hand side, it's all in Spanish, but we can use an interpreter to maybe explain the hospital bill. He can read the document and explain to the court.
I
how
don't
much.
need an explanation.
Thank you.
I cannot fluently speak Spanish. However, I can read Spanish.
Thank you.
It's actually similar to French. Actually, your account.
Thank you.
All right, this is what the court is going to do. The court is going to set your bond at $30,000. Who's the complainant?
Azamet Balderas, that is spelled AZUNHET.
H-E-T.
Yes, Your Honor. And then Torres is common spelling TORRES.
All right, the court is going to set your bond at $30,000. There should be no contact with Azamet Torres. And there's to be GPS partial for employment until further notice. And I'll ask that GPS fees be waived. And Norma, give him a set date. Your jury trial date is set for November 4th. Thank you.
You know,
You're welcome. Donata? Yes. Okay, all right. Thank you.
Your Honor, may I get a signature?
Yes.
Thank you.
There you are.
Your Honor.
But he can stay in Laredo, Your Honor. He can live in Laredo.
I'm sorry, what?
He can live in Laredo.
I'm not in charge of his residence. All I'm telling you is that he's on GPS. His bond is set at $30,000 and he's not to have any contact with that complainant. If he does, a warrant's going to be issued for his arrest. Thank you.
Maybe she's on.
Yes, once he gets his reset paper.
A woman pleads guilty to meth possession, expecting a short jail term. But what she gets instead is a chilling warning from the judge, one that could save her life.
When you're released from custody, if you cannot find a sober living place or you need some help finding a place to go, if I'm still here, you come back here, I will pick up the phone and call somebody to help you. You understand? Come up, Christy Rios. Court is calling 2025 CR 008178 State versus Christy Emilio Rios. Could I have parties announced?
Robert Brabant for Rios.
And are you Miss Rios?
Yes, ma'am.
I'm so sorry about mispronouncing your name. You can lower your hand. Counsel, have you received all discovery?
Yes, ma'am. I have.
Did you review it with your client?
Yes, I did.
Court will find that the state is in compliance with discovery. Are there any applications in this case?
No application, Judge.
Ms. Rios, did you review the true bill of indictment with your attorney? Did you understand it? Counsel, do you waive the reading of the indictment?
Yes, ma'am.
State, are you proceeding on the indictment as presented?
Yes.
Did you review the court admonishments with your attorney? Did you understand it and sign it in all the appropriate places?
Yes.
You're charged with possession of a controlled substance, penalty group 1, less than 1 gram. That's a state jail felony. Range of punishment is anywhere from 180 days up to 2 years in the state jail facility and up to a $10,000 fine. If you have a plea bargain agreement with the state, the court does not have to follow your plea. If for any reason the court does not follow your plea and gives you more than you bargained for, the fact that you entered a plea will not be used against you and you will be allowed to withdraw your plea. Did you understand? You have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call, and the right to remain silent. By entering this plea, you're giving up those rights. Did you intend to give up those rights and enter a plea in this case? Counsel, has your client have been able to provide you with any defenses?
Yes, Your Honor.
Do you believe she has a rational as well as a factual understanding of the charges against her?
Yes, I do.
Do you believe she's currently competent and was legally sane at the time of the offense?
Yes, she's mentally competent. Yeah.
Ms. Rios, has anyone threatened you, coerced you, or placed you in fear to get you to enter this plea? Anyone promise you anything other than the plea? Are you satisfied with the way you've been represented? If you're not a U.S. citizen, by entering this plea, you will be deported, not allowed re-entry, and denied naturalization. Did you understand?
Yes.
Court will find that defendant has knowingly and voluntarily waived her right to jury trial. Did you review the plea bargain page with your attorney, and did you understand it? According to the plea, punishment is to be assessed at 96 days in the Bexar County Jail under 1244, and there's a $1,000 fine and no applications. Did you understand that to be the plea? Defense, is that the plea?
Yes, ma'am, it is.
State, is that the plea?
It is.
Did you review the waiver of appeal paragraph with your attorney? Did you understand it and sign it in both places? By signing that, you're waiving your right to appeal. The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand?
Yes, ma'am.
Counsel, have there been any such motions?
No, yeah.
Then to the offenses charged, how do you plead? Guilty, not guilty, or no contest? State, any evidence to support the defendant's plea?
Stenographer states 1 and attached.
No objection, Your Honor.
Did you review the waiver and stipulations with your attorney? Did you understand it and sign it in all the appropriate places? Again, did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call, and the right to remain silent? Did you understand that today the state will be presenting evidence in the form of witnesses' statements and police reports, but most importantly, there'll be no live testimony? Did you understand? Court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence states exhibits 1 and attachments and review the same. State, you may be excused. Thank you. After reviewing states exhibits 1 and attachments, the court will find there is sufficient evidence to find you guilty. The court will find you guilty. Are you proceeding with sentencing?
Yes, we are, Your Honor.
Anything you wish to say on behalf of your client?
No, just to follow the plea agreement.
All right, the court will follow your agreement, sentence you to a $1,000 fine. Time and money will run concurrently. The court will sentence you to 96 days in the Bexar County Jail under 1244. and give you credit for any time served. Did you review the document entitled Trial Court Certification of Defendants' Rights to Appeal with your attorney? Did you understand it and sign it? Because this is a plea bargain agreement, because I followed your plea bargain agreement, because you waived your right to appeal, you do not have the court's permission to appeal. Because this is a felony conviction, you're not allowed to own or possess any weapons or ammunition. If you have a question over what a weapon or ammunition is, you need to speak to an attorney. Do you understand? Yes. All right, we can go off the record. Here's the thing. Obviously, you have a drug problem, right? When you're released from custody, if you cannot find a sober living place, or you need some help finding a place to go, if I'm still here, you come back here, I will pick up the phone and call somebody to help you. You understand? Because if you continue like you are, only one or two things going to happen. Either you're going to be in and out of jail, in and out of prison, or somebody may end up having to identify your body, because the last time you use may be the last time you use. You understand? All right. Good luck to you. Thank you,
Thank you,
counsel.
Judge.
Who's next?
Good day.
Hello, Mr. Gutierrez. All right, the court is calling 2024 CR 012855 State versus Christopher Gutierrez. Can I have parties announced?
Ronald Arguelles for Mr. Gutierrez.
And are you Mr. Gutierrez? All right, Mr. Gutierrez, Mr. Arguelles was appointed to represent you. Your previous counsel had a medical issue and asked that they be removed from your case. Your attorney is entitled to 10 days to prepare for trial. Of course, he was just appointed. Do you still wish to continue, or do you wish for him to have 10 days?
All right. Get it all done.
I'm sorry?
Get it all done with.
All right. And Mr. Arguelles, are you waiving your notice?
Yes, Your Honor.
And have you had sufficient time to speak with your client and review the case?
Yes, Your Honor.
All right. And counsel, have you received all discovery?
Yes, Your Honor.
Court will find that the state is in compliance with discovery. Mr. Gutierrez, did you review the true bill of indictment with your attorney? Did you understand it?
Yes, ma'am.
Counsel, are you waiving the reading of the indictment? Counsel, are you
Yes,
waiving
Your
the
Honor.
reading? State, are you proceeding on the indictment as presented? Any objection?
No objections, Your Honor.
Mr. Gutierrez, did you review the court admonishments with your attorney? Did you understand it and sign it in all the appropriate places?
Yes, ma'am.
You're charged with theft of property less than $2,500 with 2 or more previous convictions. The punishment range is as a state jail felony. Range of punishment is anywhere from 180 days up to 2 years in the state jail facility and up to a $10,000 fine. If you have a plea bargain agreement with the state, the court does not have to follow your plea. If for any reason the court does not follow your plea and gives you more than you bargained for, the fact that you entered a plea will not be used against you, and you will be allowed to withdraw your plea. You have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call, and the right to remain silent. By entering this plea, you're giving up those rights. Did you intend to give up those rights and enter into a plea in this case? I'm sorry? No. I'm going to go through it slowly with you. And if there's something, here's the thing, take a deep breath. All right, so I'm going to go over this slowly with you. If there's something you don't understand, let me know, all right? And counsel, I know that you've explained this.
Yes, Your Honor.
Sometimes questions are complicated, so I'm just going to break it down. Do you understand you have a right to have a jury? That would be 12 people who would sit, and they would get a chance to hear whatever evidence the state would bring, and that evidence would be brought in the form of witnesses. Do you understand?
Yes, ma'am.
And your attorney would have a chance to cross-examine those witnesses. Do you understand?
Mhm.
And do you understand the state would not be able to call you as a witness if this were a jury trial? Do you understand?
Yes, ma'am.
All right, because you're entering into this plea bargain agreement, the state is not going to call any witnesses. Your attorney is not going to get a chance to question any witnesses. Do you understand? And do you understand also that if anyone wants you to testify, you've given up the right to say, I'm not going to testify. Do you understand?
Yes, ma'am.
All right. Is there anything you do not understand?
Mhm.
All right. Oh, thank you. Counsel, has your client been able to provide you with any defenses?
Yes, Your Honor.
Do you believe he has a rational as well as a factual understanding of the charges against him?
He does, Judge.
Do you believe he's currently competent and was legally sane at the time of the offense?
Yes, Your Honor.
Mr. Gutierrez, has anyone promised you anything than what the agreement is?
Amen.
Has anyone threatened you, coerced you, or placed you in fear to enter into this agreement? All right. Are you satisfied with the way you've been represented? Did you understand by entering this plea, if you're not a U.S. citizen, you will be deported? Do you understand? If you're not a U.S. citizen, you won't be allowed to legally re-enter the United States. Do you understand? If you're not a U.S. citizen, you are going to be denied naturalization. Do you understand? Court will find that defendant has knowingly and voluntarily waived his right to jury trial. This is your plea bargaining agreement. Did you review it with your attorney? Did you understand it? So what you've agreed to is to serve 1 year in the state jail facility. There's $1,000 fine. What I can tell you is legally, whatever time that you've been in custody, I have to give you credit for that time. Do you understand? But for the court, your agreement is 1 year in the state jail facility and $1,000 fine. You're not applying for probation or deferred adjudication. Did you understand that to be the plea? Defense?
Yes, Your Honor.
State? This paragraph, that's the waiver of appeal paragraph. Did you review that paragraph with your attorney? Did you understand it? Did you sign it in both places? When you sign that, that means that you're waiving your right to appeal. So you can't come back and complain about this plea unless your attorney has filed some motions. I've heard those motions and made a ruling on them. Do you understand? Counsel, are there any such motions?
No, Your Honor.
So to the offense that you're charged with and this indictment, how do you plead? Guilty, not guilty, or no contest? State any evidence.
No objections, Your Honor, for purpose of the plea.
All right, and state you may be excused. Did you review this document? It's the waiver and stipulations. All right. Again, you understand you can go to trial if you want to go to trial. You understand? All right. So did you understand and sign this document and all the places you should sign it? Did you understand that the state, again, they're going to present their evidence to prove your guilt by entering into the record police reports and any prior judgments that you have to prove jurisdiction? Do you understand? Court will find that defendant has knowingly and voluntarily waived and stipulated to testimony of stipulations. Court will accept into evidence state exhibits 1 and attachments, and the court is reviewing the same. All right, counsel, is your client stipulating that the person who's listed as S1 is also D1, and that is your client?
Correct, Your Honor.
All right, after reviewing states exhibits 1 and attachments, the court will find there's sufficient evidence to find you guilty, and the court will find you guilty. Are you proceeding with sentencing?
We are, Your Honor.
Anything you wish to say on behalf of your client?
That the court follow the agreement.
All right, the court will follow your agreement. The court is going to sentence you to 1 year in the state jail facility. There's $1,000 fine. Time and money run concurrently. I'm going to give you credit for any time served. I'm going to suggest the therapeutic community or recommend that. It will still be up to you whether or not you want to be in that program. It doesn't increase the time you're in custody. It's just to help you with any type of issues you may have, be it mental health issues or drug issues. Do you understand? All right. Did you review the document entitled Trial Court Certification of Defendant's Rights to Appeal with your attorney? And did you understand it? Because this is a plea bargain agreement, because I followed your plea bargain agreement, and because you waived your right to appeal, you do not have the court's permission to appeal. Because this is a felony conviction, you're not allowed to own or possess any weapons or ammunition. If you have a question over what that is, you'll need to speak to an attorney. Do you understand? All right, we can go off the record. Mr. Gutierrez, you're going to have to change, because you're going to get to a point where these state jail felonies, the range of punishment is going to end up being 2 to 20. You understand? All right, good luck to you.
Thank you, Your Honor.
Thank you. You too. Thank you, counsel.
He broke probation, picked up new theft charges, and now faces prison. But when his father stands up to speak, everything changes. Will compassion win over the law, or will justice demand time behind bars?
He's released and he immediately picks up with another theft case. That's in May.
Yes, Your Honor. The theft cases, I believe, are shoplifting.
And the missing witness is Mr. Green. All right. Are you all still having your contested?
No, Your Honor. We've reached an agreement, I believe.
All right, the court is calling 2023 CR 10024, State versus Reginald Tyrone Green. Can I have parties announced?
Those for the state.
Andres Camping for Mr. Green.
And are you Reginald Tyrone Green?
Yes.
Did you review the documents entitled Motion to Enter Adjudication of Guilt and Revoke Community Supervision and First Amendment Motion to Enter Adjudication of Guilt and Revoke Community Supervision with your attorney? Did you understand it?
Yes.
Are you the same Reginald Tyrone Green who was placed on deferred adjudication in 2023 CR 10024 for the offense of unauthorized use of a vehicle on April 16, 2025 for a period of 2 years? Is that you?
Yes, Your Honor.
All right, state.
Violated condition number 1, on or about the 21st day of May 2025 in Bexar County, Texas, the defendant Reginald Tyrone Green committed the offense of theft in violation of condition number 1.
How do you plead to that? True or not true?
True.
State will waive all others.
Any objection?
No objections, Your Honor.
All right, did you understand by pleading true to violation of condition number 1, the court could find it true, grant the motion, find you guilty, and sentence you up to 2 years in the state jail facility and up to a $10,000 fine?
Yes, Your
Knowing that, do you still wish to plead true to violation of condition number 1? Court will find violation of condition number 1 true. Is there a proposed agreement?
Yes, Your Honor, the proposed agreement is to grant state's motion to revoke sentence to 180 days in the state jail facility and take it to consideration clause number 2025 CC 007955.
All right, and that cause number, what is that cause number?
That is the theft Mr. Green pled to.
All right. And then as a part of your previous plea bargain agreement, the court was asked to take in consideration county court cause number 70, if everybody could write this down, 709056 and 709057. And what were those cause numbers? The offenses.
I'll be close to the one that we're
Yeah.
taking in 007955 and then 707056.
All right, I'll see if I can look it up. Yes.
So cause number 709056 is a criminal trespass, and the other is a resisting arrest.
All right. So what has he done on probation other than pick up another theft case? Has he completed anything?
Your Honor, I don't believe he has been out on bond long enough to complete anything. It's my understanding that Mr. Green has been struggling with some mental health issues and is ready to accept any and all help that the state will offer. The underlying offense, I believe, is a unauthorized use of a motor vehicle that stems from a confusion with his parents. His father is here, present, and is standing behind and supporting Mr. Green. I do not believe that Mr. Green has successfully completed any of the other conditions of his supervision, but the desire is to pay his debt to society and then to relocate up to Texarkana with his family. And then be with his support network up there so they can help assist him in getting on track with everything.
All right, what I can tell you both is I don't think 180 days is appropriate. He was on probation for unauthorized use of a vehicle.
Yes, sir.
Which is sort of close to being a theft. Sometimes the state will file it as a theft of a vehicle. Sometimes they will file it as just unauthorized use. And then while he's on probation, he's released and he immediately picks up with another theft case. That's in May.
Yes, Your Honor. The theft cases, I believe, are shoplifting, not a forceful dispossession. And from what I understand, there may have been some other factors at work, but from our perspective, the decision to request that the state offer Mr. Green the ability to serve some time on their revocation was something that was agreed upon by all parties to help facilitate Mr. Green's getting past all of these incidents. I do believe he has a number of days in custody as credit that we would ask the court to attribute to him. But
he has an unauthorized use that he's on probation for April 16, 2025. He doesn't do anything on probation. The only thing he does is pick up another theft case on May 21st, 2025. I'm assuming he gets arrested at some point in time for that, gets released, and then in June, he's alleged to have committed another theft of 2025. I just don't think 180 days is appropriate for him because he hasn't done anything on probation other than pick up new offenses. Y'all are dimming the lights. All right, so this is what the court is going to do. The court is finding you guilty, finding, as previously stated, found violation of condition number 1 true. The court is revoking. The court is taking in consideration 2025 CC 007955. The court will sentence you to 14 months in the state jail facility, give you credit for any time served, and the court will request the therapeutic community.
Your Honor, if the court would entertain a little bit of testimony as to the underlying, if that might
Sure.
have the court can reconsider in its assessment. We would like to call Reginald Green, Senior.
Mr. Green, here, you're back against.
Could you raise your right hand for me, please? Do you solemnly swear or affirm the testimony you give will be the truth and nothing but the truth, so help you God?
Nothing but the truth.
All right, you can lower your hand, state your name for the record.
Reginald Green.
All right, yes.
Mr. Green, who are you in relation to Reginald Tyrone Green?
That's my son.
Okay, and are you familiar with the underlying charges of the unauthorized use of a motor vehicle?
Yes, that was our vehicle that we gave to him. He was going through a breakdown at the time. He brought the car to get the what's called miles to get some work done on it. It came up to be $1,000-some. With his breakdown, he just figured he could go get the car, take the car. The people saw his state. They didn't press charges. We paid the $1,000, but my wife decided to take the car back because of his mental state.
Okay, so let me stop you right there. So here's the thing. Once somebody has been placed on probation, they're placed on probation. It would probably be best for you if you are now saying that he is innocent of these charges, didn't commit these charges. That's something for the public integrity unit of the district attorney's office. But I cannot legally go back and undo the fact that he's on probation.
He mentioned it.
Yeah.
I understood.
So here's my thing. Why, if you know, why is your son, he's on probation for a theft case, and he, the unauthorized use, and he continues to pick up more theft cases?
Because he was going through a mental situation. We committed him into the hospital because.
And when was he committed into the hospital?
I can't recall right now, but it is record that he was there. But the thing is with Reginald is with his kids. His kids are more important to him. His wife used his kids to keep him from seeing it. He gets, because he's not stable, he gets upset. So that's why she puts him on where he can't come. Then, so he don't know how to handle that. So he do that, like he really don't have a place to live. So when he was stealing, he was just trying to get it wrong. I've been trying to get it to Texas County because I know I can help him. But leave his kids. No one wants to see that. If you knew Reginald, you would know. He's a person that gives assurance. He's a hard worker. It's a long story. He don't just get here. this was a long process. That trying to do the right thing instead of hitting the wall. He got arrested this time. He was on his feet. By him being on his feet and get arrested, he loses his job. So now he starts over. Now he has no, because the main thing is for him, his paying his child support. His father support was taking his majority of his whole check because he had 3 children. He loved his children. He had a spot on that. But when he lost his job, he had nowhere to live. So again, he refereed whatever hustle he could get to get a room, just a roof over his head. And that's what he was supposed to.
All right.
And so, Your Honor, I offer this testimony.
Just 1 second.
My apologies.
Do you have any questions? All right. Thank you so much for letting me know about your son.
Your Honor, I offer this testimony so that the court could maybe reconsider its decision in its sentencing, knowing that Mr. Green is going to be getting the help that his family wants to offer, and that they would love to have him come up there to Texarkana, but they do understand that he needs to be admonished and punished and has to take some responsibility. And they're not trying to obfuscate that, and they're not asking the court to ignore that. They're just asking that if the court would to follow the plea agreement, that they believe that they would be able to be in a position to help Mr. Green once he is done with his sentence and can be back with his family in Texarkana, hopefully to get him back on his feet and assist him in any other way possible, as not just being his family in present, but also being someone that he can rely on and not have to.
Do you have proof of his mental health issues?
I do not on me at this time.
All right. So this is what the court is going to do. The court sentence will remain to guilty, revoked, taking consideration 2025 CC 007955. 14 months in the state jail facility, give you credit for any time served in the therapeutic community. If your counsel brings proof to the court of mental health issues, proof to the court from your family of some sort of plan, then the court will reconsider if the state has no objections. And I say if the state has no objections because there truly is no legal motion that's a motion to reconsider. Once the court enters a legal sentence, that legal sentence stands. So the state would have to agree to allow the court to reconsider. Do you understand?
Yes, please.
All right. Did you review the document entitled Trial Court Certification of Defendants' Rights to Appeal with your attorney? Did you understand it and sign it? All right. You have a limited right to appeal. That right to appeal is as it relates to the allegations in the motion, not the fact that you are on deferred adjudication. Because this is a felony conviction, you're not allowed to own or possess any weapons or ammunition. If you have a question over that, you'll need to speak to an attorney. Do you understand?
Yes.
All right. Thank you. And when do you anticipate having that information?
I will get it to the state if I can before the end of the week.
All right, then you need to speak with Ms. Ferguson about putting it on the docket for a motion to reconsider.
Yes, Your Honor. Thank you very much.
Have the courage to grant him.
Oh, well, it's not a matter of my having courage.
Sorry, Judge, and I apologize. I wasn't trying to offend you by any means. If you.
All right, the court is calling 2023 CR 3. I'm sorry. 2023 CR 9393, State versus Darwin Gomez Jr. Could I have parties announced?
Megan Galloway for the state.
Mark Litt for defense, Judge.
And are you Darwin Gomez?
Yes, Your Honor.
All right, you entered a plea, and according to your plea bargain agreement, punishment is to be assessed at 10 years in the prison. There's a $2,000 fine, affirmative finding of deadly weapon. The state is opposed to your application of deferred adjudication, and there's to be restitution, if any, to the complainant. Have both parties had a chance to review the PSI report?
Yes, Your Honor.
Any objections to the PSI report by any party?
Not from defense, Judge.
All right. And are there any witnesses?
No, Judge. We provided the court with a packet and then argument.
All right. And so state any objections to the court reviewing the packet?
No, no.
All right. So if I could have that back. Thank you. And let me review this.
Yes, Judge.
Right. The court has reviewed the package you wanted the court to see.
Thank you, Your Honor.
All right. And state you have no witnesses?
No, Your Honor.
All right. So the first thing I would like for you to address, and maybe you can address it through your client, it says that guilt was minimized in the PSI. What is that about?
And if you want to ask Mr. Gomez himself, you're obviously more than welcome to. I was shocked when I read that because in all the conversations that I've had with him he took responsibility for the plea, despite my urging to go to trial, because he did accept responsibility to me many times. So I don't know if it was just miscommunication and I'm sure he can explain that to you himself, Judge.
All right. You want to raise your right hand? Do you solemnly swear and affirm the testimony you give will be the truth and nothing but the truth, so help you God?
Yes, Your Honor.
All right. You can lower your hand. Is there something you wish to say?
Completely regret everything that I ever did in regards to that, Your Honor. I was entirely in fear for my life, but regardless of the fact, I should have left it in God's hands and not took it into myself. And there's not a day that goes by that I don't regret what I did. I put my whole family and my wife through hardship. I never meant to do that. They all rely on me a great deal. A lot of people do. And the incident happened a month after I had just gotten married. Well, the biggest thing for me being fearful at that moment, I was not justified. I should have just left it in God's hands. I feel like a fool. But I'm grateful to the Lord because I've gotten closer with Christ since the incidents happened. But I feel terrible. I feel terrible about everything that had happened in that incident. And I don't ever want to do that, anything like that again. I have no firearms any longer. I don't have any intentions of going back to my lifestyle. I'm with the IBEW Local 60 Union now, ma'am, and I'm working to get my journeyman's license. And the past couple of months, I've been working on leaving San Antonio, Texas to go to Bigfoot, Texas, to be in the countryside. And I don't plan on ever going back to doing anything near like that again. And in the instance that something does happen like that, I will happily leave it in God's hands. Whether it be me dying, me being disabled, or whatever it is. But I don't ever want my wife to be fearful to be without me or my mother and not think that I can raise my siblings or help my siblings. And it's not an excuse, Your Honor, but I want you to know that there's not a night that goes by that I don't think about the man and about what I did. I want you to know that from the bottom of my heart.
State, any questions? No. All right. And State, have you had a chance to review the packet? All right. And State, are you still proceeding with the plea?
Yes, sir.
All right. All right, State.
Judge, just given the evidence that was stipulated to your opposed and the offsite deny that.
All right, defense.
Briefly, Judge, a couple of things. Without sounding cheesy, but for the grace of God, I mean, choosing to discharge a firearm, whether he hit somebody, missed somebody, or God forbid took a life, is literally but for the grace of God. And I think the minimization is the fact that he believed, rightfully or wrongfully so, that a road rage incident was going on. And that's why that's probably, after hearing him talk now, because like I said, our conversations were always like he did right now, which he was remorse for it. What I can say is this: the complainant, as you can see in the PSI, leaves it to you. He's not asking for prison. He just wants to ensure two things. One, he would like to get, I think he's out $6,300 that he lost with regards to his hospitalization and treatment. And he wants to ensure that nothing like this ever happens again with the defendant, Judge. And so starting from that, what I can tell you is this, is that in a perfect world, this never would have happened. The only positive I can say, and it sounds like a cheesy defense lawyer saying, but I've been doing this for almost 20 years, and I can say that I have, from the very first meeting with Mr. Gomez to now, I have seen not only the words of genuine remorse, but the actions to show that he's actually taking steps to change his behavior, change his actions, to be a productive member of society. When I think of, do I believe that some people deserve to go to prison? Without a doubt. And the question I've always asked myself, I've never had the honor or the privilege or the burden of sitting in your seat, but I always ask myself, is society better served with the person behind bars or the person continuing to be a productive member? In Mr. Gomez's case, he has gotten a great job, and a great job isn't a reason to keep someone out in and of itself, but he does have a good job. He's an electrical apprentice working on his way to journeyman. He's currently earning almost $5,000 a month, and he has a lot of progress within the company and within vertical moving. With regards to his views of what happened that night, the choice he made was obviously the wrong one and a dangerous one. The smart thing would have been to have called 911. Unfortunately, playing Monday morning quarterback, judge, is not something that we had the luxury of going back and changing it. But his actions while on bond, with employment, with his family.
So sorry.
The PSI, when it did the evaluation, did say that he is a low to moderate risk, and they confirmed that he has a very strong and a very large support network of both family, friends, and colleagues. He doesn't have a drug problem, doesn't do drugs, doesn't drink. His problem has been his response to immediate, confrontation or anger, as you've seen through his record. But I do believe, without a doubt, that one, he has taken steps to show that it's not just words, Judge, that taking steps to show that he has, one, understood how horrible and stupid what he did was, but also steps in the future of how never to be before this court, never to put someone's life in danger, never to be on this side of the criminal justice system again, Judge. If you have the courage to grant him.
Oh, well, it's not a matter of my having courage.
Sorry, Judge, and I apologize. I wasn't trying to offend you by any means. If you grant him deferred, you won't, I am confident in saying that you will not be mistaken, embarrassed. He will not be before this court for an MTR or any other court for a criminal offense. He will successfully complete all conditions and terms of his deferred adjudication, and will be able to, which I've found is sometimes most helpful, is be able to pay it forward with regards to helping other people realize that, the decisions we make not only have real world immediate consequences for other people, but for society and for the families as a whole. We would humbly ask that you grant him deferred adjudication. I've explained to him that deferred subjects him to the full range of punishment, not just 10 years. And this court has a heavy hammer over his head. We just ask for the opportunity, Your Honor, humbly.
May I say something, Your Honor?
Sure.
For the past 2 years that I've been going to coming to court and going about the reschedulings and so forth, I've made it number one priority out of everything in my life to make sure that I get here no matter what it is, whether I'm in Oklahoma, I'm in Paris, Texas, or Rogers, Texas, or anywhere in Texas. And I'm very grateful that y'all have given me the opportunity to appear via Zoom, and have been very lenient with me as far as appearing here to make something like this possible. But I do want to let you know that it is my number one priority to be as on time as I possibly could for any event or anything that y'all need me to do or need me to cooperate with. It's just, I want to be as cooperative as possible, and I don't ever want to look at anything like this again in my life, Your Honor. And I'm grateful to even be standing here in front of you, because 2 years ago, I remember sitting in jail next to a man who stabbed his brother in the neck. And I thought that was it. That was my last opportunity to even see the outside world. And for this past 2 years, I've seen miracle after miracle after miracle. And I've met so many people that I never thought I'd meet and seen so much that I never thought I'd seen. So I do want to let you know that I am a man of my word, and it's all I have. And I plan on staying and sticking to it no matter what.
All right. So here we can go off the record. Here's the court's question. Let me just tell you, sometimes I think out loud. Sometimes what I'm thinking out loud, these are just thoughts. Sometimes it's hard to send somebody to prison when you see that they've changed their life, but they've done something bad. And so with you, I'm balancing what you've done. I'm balancing where you are now. I'm balancing your age. I'm balancing, the complaint. I will tell you this, the complainant in this case did you a solid, because there are some complainants who would say, I want him underneath the prison. And so what I can tell you in this is what the complainant is saying. And I'm not saying I'm going to lean one way or not, but so the complainant says they're out of pocket. Where is this? This is the time where you need one of those sticky things to turn pages.
Your Honor, I'm not a.
So the complainant says they're out of pocket $6,136.20. And what I can tell you is normally when people say they lost this amount from work, I'm like, I'm not allowed to legally give that. But he says he lost a week's pay. That's $1,096.16. And he says his vehicle is still impounded. I don't know if his vehicle is still impounded or not. I don't know how to check on that. But he's saying that vehicle is valued at $8,000. So if you add the approximately $6,000 plus the $1,000 out of work and the $8,000, that leaves a restitution amount of $15,232.36. Now, what I can tell you is I will think about this, but you probably need to speak with the state and speak with your defense attorney about this restitution amount, because it appears that's a majority of the complainant's concern.
I'll take care of it, Your Honor.
Well, no. You want to talk to your attorney about this, because what I'm telling you, this is what I've discovered in my time on the planet.
Yes, Your Honor.
Everybody says they're going to do certain things. Everybody said they're going to pay a certain amount. And then you know what ends up happening? They're on probation. They're supposed to pay a certain amount and then they don't pay it. And if there's a motion to revoke filed and it's over fees, I can't send somebody to prison for not paying money if they establish that they are unable to afford it. So whenever there's restitution, especially at this amount, I usually want a majority of it paid up front. So you may want to step back and speak with your attorney and speak with the state.
Yes, sir.
Yes, Your Honor.
Thank you, Judge.
And state, if you want to, just one moment, we'll go off the record. All right, so on this case, we're going to recall it. Norma, I need a reset date in 6 weeks. All right, so you're going to be back on November 17th. At that time, you need to come state, do you all accept cashier's check or money orders for restitution? All right, you're going to come back with the cashier's check or either a money order. Who does he need to make it out to? The complainant? All right, Ms. Galloway will give you the complainant's name and you need to have that made out to the complainant. And then after that, the court will make a decision on your application.
Yes, Your Honor.
All right, once you sign the reset form, you're excused.
Judge.
Thank you, Your Honor. God bless you.
Oh, thank you. God bless you too.
Just,
All right, so you want to talk to me about this drug issue? Because I'm telling you right now, if you're telling me you don't have a drug issue, you know what I'm gonna do? And are there no applications?
There's an application for probation, Your Honor.
All right, probation, there's an application. Court is calling 2025 CR 010422, State versus Genevie Pettis. Can I have parties announced?
Brandon Lopez standing in for Rochelle Savedo for Ms. Pettis.
And are you Ms. Pettis?
Yes,
Any objection to this attorney standing in?
No.
Counsel, have you received all discovery? Did you review it with Ms. Pettis?
We have, and we did, Your Honor.
Ms. Pettis, did you review the document entitled Application for Community Supervision with your attorney? Did you understand it?
Yes, ma'am.
Did you review the true bill of indictment with your attorney? Did you understand it?
Yes, ma'am.
All right, you're gonna have to speak up.
Yes, ma'am.
And counsel, do you waive the reading of the indictment?
We waive it, Your Honor.
Court will find that the state is in compliance with discovery. State, are you proceeding on the indictment as presented?
Yes, Your Honor.
Did you review the court admonishments with your attorney? Did you understand it and sign it in all the appropriate places?
Yes, ma'am, I did.
You're charged with possession of a controlled substance, penalty group 1, 40 to 200 grams. That's a second-degree felony. Range of punishment is anywhere from 2 to 20 years in prison and up to $10,000 fine. If you have a plea with the state, the court does not have to follow your plea. If for any reason the court does not follow your plea and gives you more than you bargained for, the fact that you entered a plea will not be used against you, and you will be allowed to withdraw your plea. Did you understand? You have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses. The state will call in the right to remain silent. By entering this plea, you're giving up those rights. Did you intend to give up those rights and enter into a plea in this case?
Yes, ma'am.
Okay, you're gonna have to speak up.
Yes.
Counsel, has your client been able to provide you with any defenses?
She has, Your Honor.
Do you believe she has a rational as well as a factual understanding of the charges against her?
I do, Your Honor.
Do you believe she's currently competent and was legally sane at the time of the offense?
In my opinion, she is.
Ms. Pettis, has anyone threatened you, coerced you, or placed you in fear to get you to enter the plea?
No, ma'am.
Anyone promised you anything other than the plea?
No, ma'am.
Are you satisfied with the way you've been represented?
Yes, ma'am.
If you're not a U.S. citizen, by entering this plea, you will be deported, denied re-entry, and denied naturalization. Did you understand?
Yes, ma'am.
Court will find that defendant has knowingly and voluntarily waived her right to jury trial. Did you review the plea bargain page with your attorney? Did you understand it?
Yes, ma'am.
According to the plea, punishment is to be assessed at 6 years in the prison. There's $1,000 fine. There's no application for deferred adjudication, and the state recommends community supervision. Did you understand that to be the plea?
Yes, ma'am.
Defense?
Yes, Your Honor.
State?
Yes, Judge.
Did you review the waiver of appeal paragraph with your attorney? Did you understand it and sign it in both places?
Yes, ma'am.
By signing that, you're waiving your right to appeal. The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand?
Yes, ma'am.
Counsel, have there been any such motions?
No, Your Honor.
Outside the agreement, the state is requesting that your community supervision be for a term of 6 years. There be a TAP evaluation, 200 hours of community service restitution, no contact with Justin Kane, and the DOEP course. Did you understand those were recommendations from the state, and the court does not have to follow those recommendations?
Yes, ma'am.
To the offenses charged, how do you plea?
No contest.
State, any evidence?
Yes, Your Honor. State offers State's Exhibit 1 and all attachments.
No objection, Your Honor.
All right, state, you may be excused. Did you review the waiver and stipulations with your attorney? Did you understand it and sign it in all the appropriate places?
Ma'am.
Again, did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses? The state would call in the right to remain silent.
Yes.
Did you understand that today the state will be presenting evidence in the form of witnesses' statements and police reports, but most importantly, there'll be no live testimony? Did you understand?
Yes, ma'am.
Court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence State's Exhibits 1 and attachments, and the court will review the same. All right, after reviewing State's Exhibits 1 and attachments, the court will find there is sufficient evidence to find you guilty, and the court will find you guilty. Are you proceeding with sentencing?
We are, Your Honor.
Anything you wish to say on behalf of your client?
We just asked the court to follow the plea bargain, Your Honor.
All right, do you have any children?
Yes, I do.
What are their ages?
22, 21, 15.
All right, who's with the 15-year-old?
My ex-husband,
All right, and who is Justin Kane to you?
a friend of mine. Just a friend.
Then why was he with you?
I work for him. He has a business. He moves mobile homes. And we were at the location where we have our mobile homes at. And I was in the wrong place at the wrong time. So,
Well, no, I mean,
but he's kind of like,
sometimes you're in the right place at the right time.
yeah.
right? So how often have you been using?
No, I wasn't mine. It was his, but he put it in a pill bottle that was my name on it because he took it from a bag that I had inside the truck.
No, you said it was yours. In the police report, I'm just going by what's in the stipulation. You claimed it all as yours.
At the time I had to, I had no choice, but.
No, I mean, there's always a choice. You can say it's not mine.
Yeah.
Is that not a choice?
Yes.
Did somebody have a gun to your head and told you
No, ma'am.
you had to say this was yours?
No, ma'am.
And I don't believe this story that he's in the business of moving mobile homes and you were helping him. That sounds very odd to me. What is the name of his moving business?
Transport.
It will be Kane Transport, right? Because his last name is Kane. So how long has your son been with his father?
A few years.
Why is he not with you?
Because we had a real bad divorce. And at the time I was a stay-at-home mother going to school, and he had the money to take care of them and I didn't.
Usually they don't give custody to a parent just because they can't afford to.
Well,
That they're the ones who can afford to
I
take
didn't
it.
have like a stability place for him. So
Why do you have a stable
I was
place?
staying at my mother's at the time.
Usually that's pretty stable if you're staying with your mom. So what else was going on?
It was just a real bad divorce. And me and him, he just had money and I did it. He just.
All right, so you want to talk to me about this drug issue? Because I'm telling you right now, if you're telling me you don't have a drug issue, you know what I'm going to do? I'm going to put you on the IVR hotline. And I'm going to send you out in the world on the IVR hotline. And the first time you test positive, a motion to revoke is going to be filed. And I'm going to see where you said that you didn't have a drug problem.
I used to have one about back, but not now. Like I've changed my life. Like I don't use anymore.
Let me just tell you, people usually do not use when they're at the jail unless they're making drugs at the jail, which sometimes they do. But there's this methamphetamine. So how long have you been using meth?
5 years.
And how often?
Once in a while.
What does once in a while mean?
Occasionally, like.
What does occasionally mean? I'm not with you.
Like, this depends. I don't use every day.
All right. So how often are you using?
Weekend.
So is this every weekend?
No.
Then how often is it?
Whenever I get a chance to get away and use.
All right. So you don't have any children. When's the last time you were employed?
It's been a minute.
All right. So it's been a minute since you've been employed. You don't have your child with you. You use when you can get away to use. If you're not employed and you don't have a child, it seems to the court that you get away a lot to use. So how often have you been using?
It's just occasionally on the weekends.
And is this every weekend? Is this every other weekend? How often is it?
Maybe like twice a month. I go out and just hang out with a couple of friends.
I don't believe you because of the amount of drugs you've had and the fact that is with this Justin Kane person. And I'm sure if I were able to find him on the street and do a UA of him, he's going to be positive for meth.
That's on him.
All right. So I'm going to make it on you because this is what we're going to do. Probation on this case. As previously stated, I'm finding there's sufficient evidence to find you guilty. I'm going to sentence you to 6 years in the prison, suspended and probated for 6 years. There's $1,000 fine. There's going to be 200 hours of community service restitution. 100 hours will be deemed satisfied upon completion of parenting classes. Proof of employment within 30 days of release. No employment as a home health care provider or with minors. No residing in a household with minors. No unsupervised contact with minors. IVR hotline with testing at least every 2 weeks. Regular reporting by Zoom or in person. in custody, the following: TAP evaluation and a referral to felony drug court. There's to be no contact with Justin Cain, Cain. Field visits one time per month until further notice. Probation, is there anything else? Is there anything else you need from the court to be successful?
No, ma'am.
Did you review the document entitled Trial Court Certification of Defendants' Rights to Appeal with your attorney? Did you understand it and sign it?
Yes, ma'am.
Because this is a plea bargain agreement, because I followed your plea bargain agreement, and because you waived your right to appeal, you do not have the court's permission to appeal. Because this is a felony conviction, you're not allowed to own or possess any weapons or ammunition. If you have a question on what that is, you'll need to speak to an attorney. Do you understand?
Yes, ma'am.
All right, good luck to you.
Thank you.
You're welcome.
Thank you, Judge.
Okay, when they picked me up, that car, we're putting speakers into the car, and we had the panels off.
Court is calling 2025 CR 010372, State versus Javier Jorge Balderas. Can I have parties announce?
Brandon Lopez for Mr. Balderas.
And are you Mr. Balderas? Counsel, have you received all discovery? Did you review it with your client?
We have, Your Honor, and we did review it.
Court will find that the state is in compliance with discovery. Mr. Balderas, did you review the application for community supervision with your attorney? Did you understand it and sign it? Did you review the true bill of indictment with your attorney? Did you understand it? Counsel, do you waive the reading?
We waive reading, Your Honor.
State, are you proceeding on the indictment as presented?
No, Your Honor, state will be waiving the enhancement allegation.
No objection, Your Honor.
Did you review the court admonishments with your attorney? Did you understand it and sign it in all the appropriate places?
Yes, sir.
You're charged with unlawful possession of a firearm by a felon. That's a third-degree felony. Range of punishment is anywhere from 2 to 10 years in prison and up to $10,000 fine. If you have a plea with the state, the court does not have to follow your plea. If for any reason the court does not follow your plea and gives you more than you bargained for, the fact that you entered a plea will not be used against you, and you will be allowed to withdraw your plea. Did you understand?
Yes, ma'am.
You have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state will call, and the right to remain silent. By entering this plea, you're giving up those rights. Did you intend to give up those rights and enter into a plea in this case? Counsel, has your client been able to provide you with any defenses?
He has, Your Honor.
Do you believe he has a rational as well as a factual understanding of the charges against him?
I do, Your Honor.
Do you believe he's currently competent and was legally sane at the time of the offense?
In my opinion, he is, Your Honor.
Mr. Balderas, has anyone threatened you, coerced you, or placed you in fear to get you to enter this plea?
No, ma'am.
Anyone promised you anything other than the plea?
No, ma'am.
Are you satisfied with the way you've been represented?
Yes, ma'am.
If you're not a U.S. citizen, by entering this plea, you will be deported, denied naturalization, and denied re-entry. Did you understand?
Yes, ma'am.
Court will find that defendant has knowingly and voluntarily waived his right to jury trial. And I'm sorry, counsel, are you listed as the attorney of record?
And Your Honor, you're right. I am here on behalf of Rochelle Savella, representing.
Any objections to this attorney standing in?
No.
Right. Next, I want to, did you review the plea bargain page with your attorney? Did you understand it?
Mm-hmm.
You need to say yes or no.
Yes, ma'am.
Okay.
Sorry.
According to the plea, punishment is to be assessed at 8 years in the prison. There's a $1,000 fine. State recommends to community supervision. They're taking in consideration 2025 CR 010373. Did you understand that to be the plea?
Yes, ma'am.
Defense, is that the plea?
It is, Your Honor.
State, is that the plea?
Yes, Your Honor.
Did you review the waiver of appeal paragraph with your attorney? Did you understand it and sign it in both places?
Yes, ma'am.
By signing that, you're waiving your right to appeal. The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand?
Yes, ma'am.
Counsel, are there any such motions?
No, Your Honor.
Outside the agreement, the state is requesting that your community supervision be for a term of 6 years. There be a TAP evaluation, 200 hours community service restitution, and no firearms in the DOEP course. Did you understand those are recommendations from the state, and the court does not have to follow those recommendations?
Yes, ma'am.
To the offenses charged, how do you plead?
No contest.
State, any evidence?
Yes, Your Honor, state offers State's Exhibit 1 and all attachments.
No objection, Your Honor.
All right, state, you may be excused. Did you review the waiver and stipulations with your attorney? Did you understand it and sign it in all the appropriate places?
Yes, ma'am.
Again, did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call in, the right to remain silent?
Yes.
Did you understand that today the state will be presenting evidence in the form of witnesses' statements and police reports? But most importantly, there'll be no live testimony. Did you understand?
Yes, ma'am.
Court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence states exhibits 1 and attachments and review the same. After reviewing states exhibits 1 and attachments, the court will find there is sufficient evidence to find you guilty, and the court will find you guilty. Are you proceeding with sentencing?
We are, Your Honor.
Anything you wish to say on behalf of your client?
We ask the court follow the plea bargain, Your Honor.
All right. Do you want to spend the rest of your life in prison?
No, ma'am.
Then why are you doing this?
I'm gonna tell you what happened. If
Well, I mean, I'll listen to you, but here's the thing. If you're going to say something that's outside the stipulations, I can only go with what's in the stipulation.
no, I'm gonna tell you why I had the weapon.
Okay, sure.
Okay, the reason why I had the weapon was, a year ago this month, I was shot outside my house by a random person. They still don't know who it was. Okay, and I have a 15-year-old son that I got sole custody of. His mom died 3 years ago. I have an 86-year-old mom that sits there too. I take care of them. And basically I was in fear for my life, because I've been living there 35 years. I never had no problems like that. There's a police report. I drove myself to the hospital. I got a bullet hole in my leg. And
So while you're driving around in a vehicle that has no inside panels and that's been stripped on the inside,
I'm sorry?
according to the stipulations, it says,
Oh, I understand I know. Okay, that they had no inside panels. It was because when they picked me up, okay, when they picked me up, that car, we're putting speakers into the car, and we had the panels off.
Mhm.
That's why, and police officers, the 2 officers had come there before they even came and picked me up on the blue warrant, and they talked to us, so they knew what we were doing. They asked us. That's why it was open like that, because. And we're putting speakers into the car.
and was that your vehicle?
No, it's my mom's, actually.
All right. So in here, it says that you told them it wasn't your vehicle and you were you really didn't give an explanation as to why everything was missing from inside the vehicle.
Well, there was nothing missing. Everything was all the panels were in the back of the trunk.
It said the radio,
Yeah, it was we were
the
putting the radio, speakers and
the
radio.
door panel, and the lining of the vehicle was taken apart.
Well, because like I said, we were putting you can check to see it belonged to my mom. It was my mom's vehicle, and they actually let me let it go, let them take it back to her. Somebody that was there with me, I gave them the keys, and they drove it to her house. But I had the weapon. Yes, ma'am, I did. I'm not going to say I didn't have. I'm not going to lie to you.
And then this contraband, because I'm sure your mom is not driving around with drugs in her vehicle.
No, ma'am. No, ma'am. No.
So-
I had that too, and I'm not going to lie. Is because, like I said, what happened? I've never been shot before. And it kind of messed me up. No, it didn't kind of mess me up. It messed me up. And when I had,
Well, no, it says here, from my training and experience, I knew this to be methamphetamines. Suspect, that's you, quickly
Right.
stated the narcotics was not his because he borrowed the pants from an unknown person.
I don't know where they got that, because I told them it was mine. He took it out of my pocket, so I'm not going to lie. And I told him the gun was mine too. I admitted to all the stuff.
All right. Anything you wish to say?
Nothing further, Your Honor.
When's the last time you have employment?
I'm actually, what I was doing was selling hot dog carts.
Mhm.
I'm 62 years old. I was getting ready to retire and stuff, but I've been selling hot dog carts, and I had a business. It was a transmission business right there between Eisenhower and
And what happened to the blue warrant? What was the outcome?
I've discharged. They're waiting to see what happens. I've got 24 years on it, on a 25-year sentence, and I've got like 600 something days of back time, and only have like 500 something days left on it. So I should have already discharged like 100 something days ago.
All right, here's the thing. You have a choice, and this is your choice.
Okay.
One, I can follow your agreement, give you probation. or if you all want to renegotiate, I can sentence you to 2 years.
I'll take the probation.
All right. The court is going to sentence you to 8 years, suspended and probated for 6 years. There's to be regular reporting by Zoom or in person, regular random UAs, proof of employment within 45 days. There's to be no employment as a home health care provider or with minors. Take in consideration 2025 CR 010373. And how old is your child?
15. He's been with me for 11 years.
And where's the mother? Who else?
Mother died 3 years ago in July.
And who lives in the household?
My mom and my son.
All right. There's to be no unsupervised contact with minors.
I can't be around my son?
No, you can.
Okay.
Your mom just has to be there.
Okay, that's fine.
There's going to be 200 hours of community service restitution. I'm going to order parenting classes. Once that's completed, the community service hours will be deemed satisfied. Field visits 1 time per month until further notice. 30 sober meetings in 30 days. And the DOEP course. Probation, is there anything else? Is there anything else you need from the court in order to be successful? Did you review the document entitled Trial Court Certification of Defendants' Rights to Appeal with your attorney? Did you understand it and sign it? Because this is a plea bargain agreement, because I followed your plea bargain agreement, and because you waived your right to appeal, you do not have the court's permission to appeal. Because this is a felony conviction, you're not allowed to own or possess any weapons or ammunition. If you have a question over what that is, you'll need to speak to an attorney. Do you understand?
Yes, ma'am.
All right, good luck to you.
Thank you.
You're welcome.
Thank you, Judge.
You're welcome.
Judge, can we approach?
Yes.
Just off the record, I wanted to get your opinion on something.
Okay.
We've been conferring with the state. I've conferred with her for about an hour plus, hour and a half. It is my opinion that she needs a little more of a mental health, and I don't mean the mental health evaluation. I think the competency is my question. She's asking the same question over and over, and it's
So are you
mainly
saying
because
she's not competent?
I don't think she's understanding what's going on, and then I have spurts of, I think, lucidity where I think she's getting it, and now I don't think she understands. However, I do understand that the mental health component is one of the requirements where they want or possibly agreeing to plea, but I just don't feel, because the
Now,
question
here's
keeps
the
coming
thing.
up.
If you don't think she's competent, then we'll schedule her for a competency evaluation.
So what I would request is that I really don't know how to approach this, Judge. Maybe if we start the proceeding and you feel like, because I know the court can also, I don't want to be paranoid. So I don't know. I don't want to put her at more time because she has been there 6 weeks, I believe.
All right, so here's the thing. If you believe that she's not competent, then we can't proceed. So you're on community supervision, a form of probation. Do you understand?
Yes.
All right, so what you're on probation for is a 3rd-degree felony. So you're on probation for obstruction or retaliation as a 3rd-degree felony. Do you understand? All right, the range of punishment for that is anywhere from 2 to 10 years. And the reason why it's from 2 to 10 years is because you're on deferred adjudication. Do you understand? All right, so if you were to enter into a plea of true to any of the allegations that are in the motion to revoke, then I could find it true. Do you understand? And if I find it true, it doesn't matter if you have worked out an agreement with your counsel in the state, I could still sentence you to 10 years. Do you understand? Okay. All right. Just have a seat. We're going to get with you in just a moment. All right. Just have a seat.
Judge.
All right. Mr. Thomas, what I can tell you in the motion to enter adjudication of guilt, it appears to the court that you have learned nothing. All right. The court is calling 2025 CR 009050. State versus Joe Anthony Thomas. Could I have parties announced?
David McLean for the defense.
And are you Mr. Thomas? Counsel, have you received all discovery? Did you review it with your client?
I have, Your Honor.
Court will find that the state is in compliance with discovery. Mr. Thomas, did you review the true bill of indictment with your attorney? Did you understand it?
Yes, ma'am.
Counsel, do you waive the reading of the indictment?
I do, Your Honor.
State, are you proceeding on the indictment as presented?
That's our understanding, Judge. We have no objection.
And are you proceeding on both counts?
Yes, sir.
All right. Did you review the court's admonishments with your attorney? Did you understand it and sign it in all the appropriate places?
Yes, ma'am.
In count one, you're charged with aggravated assault with a deadly weapon. In count two, you're charged with unlawfully carrying a weapon with a felony conviction. Those both are second-degree felonies. Range of punishment is anywhere from 2 to 20 years in prison and up to $10,000 fine. If you have a plea bargain agreement with the state, the court does not have to follow your plea. If for any reason the court does not follow your plea and gives you more than you bargained for, the fact that you entered a plea will not be used against you and you will be allowed to withdraw your plea. Did you understand?
Yes, ma'am.
You have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call, and the right to remain silent. Did you understand?
Yes, ma'am.
By entering this plea, you're giving up those rights. Did you intend to give up those rights and enter into a plea in this case?
Yes, ma'am.
Counsel, has your client been able to provide you with any defenses?
Yes, Your Honor.
Do you believe he has a rational as well as a factual understanding of the charges against him?
I do, Your Honor.
Do you believe he's currently competent and was legally sane at the time of the offense?
I do, Your Honor.
Mr. Thomas, has anyone threatened you, coerced you, or placed you in fear to get you to enter this plea? Anyone promised you anything other than the plea? Are you satisfied with the way you've been represented?
Yes, ma'am.
If you're not a U.S. citizen, by entering these pleas to counts 1 and counts 2, you will be deported, denied naturalization, and not be allowed to re-enter. Did you understand?
Yes, ma'am.
Court will find that defendant has no. All right. Did you review the plea bargain page with your attorney? Did you understand it? According to the plea, the state is proceeding on counts 1 and counts 2. Punishment in each count is to be assessed at 8 years in the prison. There's a $2,000 fine. In count 1, there's an affirmative finding of deadly weapon. There are no applications. This will run concurrently with 2022 CR 3270 and 2023 CR 11355. Did you understand that to be your plea?
Yes, ma'am.
Defense?
That's our plea, Judge.
State?
It is, sir.
Did you review the waiver of appeal paragraph with your attorney? Did you understand it and sign it in both places? By signing that, you're waiving your right to appeal. The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand?
Yes, ma'am.
Counsel, are there many such motions?
No, Your Honor.
Then to count 1, how do you plea?
Contest.
Count 2, how do you plea?
Contest.
State any evidence to support the defendant's plea.
State's
Your Honor, I reviewed that with my client. We have no objection.
All right. Did you review the waiver and stipulations with your attorney? Did you understand it and sign it in all the appropriate places?
Yes, ma'am.
Again, did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call in, the right to remain silent?
Yes, ma'am.
Did you understand that today the state will be presenting evidence in the form of witnesses' statements and police reports, but most importantly, there will be no live testimony? Did you understand?
Yes, ma'am.
Court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence state's exhibits 1 and attachments, and the court will review the same. All right, after reviewing state's exhibits 1 and attachments, the court will find there is sufficient evidence to find you guilty, and the court will find you guilty of counts 1 and 2. Are you proceeding with sentencing?
Yes, Your Honor.
Anything you wish to say on behalf of your client?
Your Honor, we asked the court to follow the plea bargain. We've analyzed this case long and hard, along with the state's counsel, and we're hoping that we can try to get this case disposed of. We just asked the court to follow the plea bargain.
All right, then, as previously stated, the court is finding you guilty of counts 1 and counts 2. The court will sentence you to 8 years in count 1. There's an affirmative finding of deadly weapon in count 1. This will run in count 2. The court will sentence you to 11355, and there's a $2,000 fine. Is there anything else from either side with regards to sentencing?
Speaker.
Your Honor, I wanted to clarify the cases that, did you say those were being taken into consideration?
I'm sorry, concurrent with.
Thank you, Judge. Yeah, I
Thank you.
believe that
Thank
was-
you for the correction.
No, I believe that was what the agreement was.
All right, and so for the record, this cause number 2025 CR 009052 will run concurrently with 2020 CR 3270 and 2023 CR 11355, and counts 1 and counts 2 will run concurrently. All right, did you review the document entitled Trial Court Certification of Defendants' Rights to Appeal with your attorney? Did you understand it and sign it?
Yes, ma'am.
Because it's a plea bargain agreement, because I followed your plea bargain agreement, and because you waive your right to appeal, you do not have the court's permission to appeal. Because this is a felony conviction, you're not allowed to own or possess any weapons or ammunition. If you have a question over what a weapon or ammunition is, you'll need to speak to an attorney. Do you understand? All right, we're proceeding with 2022 CR 3270 and 2023 CR 11355. Did you review the document in 2023 CR 11355 entitled Motion to Enter Adjudication of Guilty and Revoke Community Supervision with your attorney? Did you understand it?
Yes, ma'am.
Are you the same Joe Anthony Tamas who was placed on deferred adjudication in 2023 CR 11355 for the office on unlawful possession of a firearm by a felon on April 2nd, 2024 for a term of 5 years? Is that you? And in cause number 2022 CR 3270, are you the same Joe Anthony Tamas who's placed on community supervision on April 28, 2022 for a term of 6 years for the offense of possession of a firearm by a felon? Is that you?
Yes, ma'am.
All right, state.
Violation of condition number 1 on or about the 18th day of April 2025 in Bexar County, Texas. The defendant, Joe Anthony Leopoldo Thomas, committed the offense of assault in violation of condition number 1.
And is that the same allegations in both motions?
It is, sir.
Then in each motion, how do you plead to that allegation? True or not true?
True.
All right. And cause number 2023 CR 11355, did you understand by pleading true to violation of condition number 1, the court could find it true, grant the motion, find you guilty, and sentence you up to 10 years in the prison and up to $10,000 fine?
Yes,
Knowing that, do you still wish to plead true to violation of condition number 1?
yes, ma'am.
Court will find violation of condition number 1 true. And cause number 2022 CR 3270, did you understand by pleading true to violation of condition number 1, the court could find it true, grant the motion, and sentence you up to 6 years in the prison?
Yes, ma'am.
Knowing that, do you still wish to plead true to violation of condition number 1? Court will find violation of condition number 1 true. Is there a proposed agreement?
There is, Your Honor. It's to grant the state's motion to revoke the defendant and sentence him to 8 years in prison.
That's our understanding, Your Honor.
All right, Mr. Thomas, what I can tell you in the motion to enter adjudication of guilt, it appears to the court that you have learned nothing. So in cause number 2023 CR 11355, the court is going to grant the motion, find you guilty, revoke. The court is going to sentence you to 10 years in the prison, give you credit for any time served. This will run concurrent with 2025 CR 009050. There should be no contact with the following persons: Christopher Michael Talamontes, Rings of Fire Tattoo. And in cause number 2022 CR, oh, and I'm sorry, this is also to run concurrent with 2022 CR 3270. And cause number 2022 CR 3270, the court is going to revoke. The court will sentence you to 6 years in the prison, give you credit for any time served. This is to run concurrent with 2025 CR 009050 and 2023 CR 11355. And there's to be no residing with minors and no unsupervised contact with minors. In each of those cause numbers, did you review the trial court certification of defendants' rights to appeal with your attorney? Did you understand it and did you sign it? All right. In each of the cause numbers, you have a limited right to appeal. That right to appeal is as it relates to the allegations in the motion, not the fact that you are in deferred adjudication or community supervision. Because these are felony convictions, you're not allowed to own or possess any weapons or ammunition. If you have a question over what that is, you'll need to speak to an attorney. Do you understand?
Yes, ma'am.
All right, yes.
Just briefly, just for my client's verification, and I know the court's probably already done this, but in each of those cases that we heard here today, my client wants to ensure that he's getting credit for the time that he's already served.
Yeah.
And at any time when he's running concurrent.
Yes.
Thank you very much, Your Honor.
All right, thank you.
Be excused, Your Honor.
Yes.
Thank you very much.
Thank you. All right, who else is ready?
Judge, I have.
Are you off docket?
Off docket.
Oh, then you're at the end.
Oh, sorry.
Page 4, one down.
Oh, just one. Yeah, yes, that is. Yes.
Naomi Aldo, page 4, one down.
Naomi Alba. All right, hello.
Hello.
What's happening with this case?
Your Honor, we're on a plea deadline today. I'm requesting a 1-week extension of that plea deadline because of the fact, 2 reasons. Number one, she is on parole right now, and she doesn't have her parole paperwork. It was lost in one of the moves, but I want to be able to contact her pre-revocation officer. And secondly, because of some of the things that she told me today relating to communications with a particular detention officer, I did not see in any of the list of discovery items anything related to that officer. I'm trying to find out if there actually exists. I've talked to the state about this, but I'm trying to find out if there's any other detention officer that might have body camera of an interaction when she was first taken to the South Tower.
All right, Ms. Ferguson, recall this for Thursday. Mm-hmm. All right.
Thank you.
You're welcome. Who's next?
It's Mr. Revolt, Darwin.
All right, so let me ask you this. When are y'all ready on Mr. Martinez thing? He's been sitting here all day.
Yeah.
All right, on Darwin, what is happening with Darwin?
I've confirmed with the state judge and my client. Don't want to overpromise and underdeliver. And I don't know how much time the court would consider. He thinks he can come up with at least about $10,000 in about 6 weeks, 8 weeks. I don't know.
Oh, just one moment.
Yes, Judge. And we initialed him, Judge.
Okay.
Sorry, that was my fault.
No problem.
I hear your notes, Judge.
Thank you. All right, state on. Please.
Yes.
So your mom is allowing you to smoke marijuana. Your mom allowed you to drop out of high school at 10th grade. So do you have a full-time job? You never really know 100%. You just have to go with your own life experiences. And sometimes it's based upon what they're telling you and what's in the reports. All right, next one.
You can pick cards. Rose.
Thank you. Hello.
Commissioner Ramos, you need to speak up nice and clear because this judge needs to hear a verbal response and that lady needs to hear it too. Okay? Nice and clear.
Thank you. And thank you for your patience.
Oh, Judge, what? You miss out on being in your court all day,
Ah, you're so awesome.
plus your personnel.
All right, the court is calling 2025 CR 007621, State versus Jesse Ramos. Can I have parties announce?
Carlos Martinez for the defendant, Your Honor.
Are you Mr. Ramos?
Yes, ma'am.
Did you review all of the discovery with your client?
Yes, Your Honor.
And have you received all discovery?
Yes, I have, Your Honor.
Court will find that state is in compliance with discovery. Mr. Ramos, did you review the document entitled Application for Community Supervision with your attorney? Did you understand it and sign it?
Yes, ma'am.
Did you review the true bill of indictment with your attorney? Did you understand it?
Yes, ma'am.
Counsel, do you waive the reading of the indictment?
Yes, Your Honor.
State, are you proceeding on the indictment as presented?
Yes, sir.
Did you review the court admonishments with your attorney? Did you understand it and sign it in all the appropriate places?
Yes, ma'am.
Did you understand you're charged with assault, peace officer, or judge as a second-degree felony? Range punishment is anywhere from 2 to 20 years in the prison and up to a $10,000 fine. If you have a plea bargain agreement with the state, the court does not have to follow your plea. If for any reason the court does not follow your plea and gives you more than you bargained for, the fact that you entered a plea will not be used against you and you will be allowed to withdraw your plea. Did you understand?
Yes, ma'am.
You have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call, and the right to remain silent. Did you understand by entering this plea, you were giving up those rights?
Yes, ma'am.
Did you intend to give up those rights and enter into a plea in this case?
Yes, ma'am.
Counsel, has your client been able to provide you with any defenses?
Yes, Your Honor.
Do you believe he has a rational as well as a factual understanding of the charges against him?
In my opinion, he does.
Do you believe he's currently competent and was legally sane at the time of the offense?
In my opinion, he is. He was and is.
Mr. Ramos, has anyone threatened you, coerced you, or placed you in fear to get you to enter this plea?
No, ma'am.
Anyone promised you anything other than the plea?
No, ma'am.
Are you satisfied with the way you've been represented?
Yes, ma'am.
If you're not a U.S. citizen, by entering this plea, you will be deported, denied naturalization, and re-entry into the United States. Did you understand?
Yes, ma'am.
Court will find that defendant has knowingly and voluntarily waived his right to jury trial. Did you review the plea bargain page with your attorney? Did you understand it?
Yes, ma'am.
According to the plea, punishment is to be assessed at 8 years in the prison. There's a $2,000 fine. State recommends community supervision. There's to be restitution upfront of $5,000 to the complainant. Did you understand that to be the plea?
Yes, ma'am.
Defense?
Yes, it is, Your Honor.
State?
It is, sir.
Did you review the waiver of appeal paragraph with your attorney? Did you understand it and sign it in both places?
Yes, ma'am.
By signing that you waive, unfold your arms. By signing that you're waiving your right to appeal, the only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand?
Yes, ma'am.
Counsel, are there any such motions?
None, Your Honor.
Outside the agreement, the state is recommending that your community supervision be for a term of 8 years. There be a TAP evaluation, 200 hours of community service restitution, and no contact with the complainant. Did you understand that was recommendations from the state and the court does not have to follow those recommendations?
Yes, ma'am.
Then to the offense as charged, how do you plead?
No consent.
State, any evidence?
It offers states.
And defense has no objections, Your Honor.
All right, did you review the waiver and stipulations with your attorney? Did you understand it and sign it in all the appropriate places?
Yes, ma'am.
Again, did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state will call, and the right to remain silent?
Yes, ma'am.
Did you understand that today the state will be presenting evidence in the form of witnesses' statements and police reports, but most importantly, there will be no live testimony? Did you understand?
Yes, ma'am.
Court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence states exhibits 1 and attachments and review the same. All right, after reviewing states exhibits 1 and attachments, the court will find there is sufficient evidence to find you guilty, and the court will find you guilty. All right, it's my understanding he has to pay restitution up front. Has that already been done?
It has, Your Honor. There was a holdup this morning.
That was the holdup. All right. Anything you want to say?
No, ma'am.
I mean, well, you should say something because I don't have to follow this agreement. So why are you doing this?
Doing what? You're right.
Do you not know why you're here?
Yes, Your Honor.
So one, why are you smoking marijuana on private property? Why don't you leave private property when people tell you to leave and it's not your private property? Why would your family give you the okay for this? Why would some random girlfriend who says she's your girlfriend say leave him alone, and then she jumps in it trying to fight the police, and then your mom comes up and is sort of like okaying that? Why? That's my why.
The venue owner had mistaken me for another person that wasn't even supposed to be at the wedding or invited. He had just showed up like a family friend.
So this,
I wasn't on the property. I was walking like back to the property, and the cop and the venue owner had mistaken me for him and told me not to come back.
no, it says, I observed the listed suspect later identified as Jesse Ramos, that's you, right? Walking in the immediate area with a blunt rolled and tucked behind his ear, and could smell the odor of intoxicants emanating from him. That's you.
Yeah, but I wasn't smoking. I didn't have nothing on me when they got me.
They said you had a blunt rolled up and tucked behind your ear.
I didn't. I probably smelled like it, but I didn't have nothing on me.
I'm reading with this. This is what you've stipulated to. And then, so there's an altercation where the police are saying, nope, you're not free to leave. They're detaining you. Then some female comes up, and they only identified her as your girlfriend, begins to interfere with the detention by pushing herself between officers and attempting to move their hands off of you. So who is this girlfriend?
She was a friend. I don't know why she called herself my girlfriend. Or did that to get in the mix.
Oh, so she did that to get in the mix?
I don't know why she did that or not, but
because you told her she was your girlfriend?
She was not my girl. I don't know why she got in though. There was no need to do that.
And then it says a large crowd of family began to approach from our rear area.
That was to try to break everything up. Yeah.
No, why? There's no need for them to break everything up. They were detaining you. And then the officer says that you put them in a headlock. And then it says a crowd began to wedge themselves between the officer and you. They ordered the crowd to disperse and told them that you were being detained temporarily and not free to leave. Another female, later identified as your mother, Ashley Marie Pettis, is that your mom?
Yes, ma'am.
All right, began to shout back that she would take him home, to which I responded, Ramos was not free to leave. Ultimately, the crowd of individuals guided Ramos beyond my initial ability to pursue. So that's what I'm talking about. Why are you doing this? And how old are you?
I just turned 21 in July.
You just turned 21 and your mom is allowing you to smoke marijuana and have blunts. How far did you go in school?
So sophomore year.
Sophomore of high school?
Yes, ma'am.
And your mom is allowing you to smoke marijuana, be out here at this hour.
That was her wedding night.
And your mom is allowing you to be out here at this hour smoking marijuana and allowing you not to graduate from high school. That's what's wrong with society today. Part of what's wrong with it. Everybody's trying to be somebody's friend instead of being a parent. Why would your mom allow you to be smoking marijuana? Are you going to say everybody at your mom's wedding venue was smoking marijuana? Your mom, I think that's your mom. She's shaking your head and said nobody was doing marijuana at her venue, I guess, except for you.
Off the property, yes, ma'am.
So your mom is allowing you to smoke marijuana. Your mom allowed you to drop out of high school at 10th grade. So do you have a full-time job?
As of right now, yes, ma'am.
Did you have a full-time job then?
In high school, I was working, yes, ma'am. That's the reason why I stopped going.
I don't know why parents are allowing this. So where do you work?
Right now, Taco Cabana. And then I work have a spot in the company. It's out of town.
What is that?
It's my cousin's. He has LLCs and businesses.
I don't know what that is, Counsel.
I think it is putting those signs for the weekends and then picking them up by Sunday afternoon or late afternoon.
We
Something
like
like
do
that.
remodeling.
And plus remodel and stuff.
So have you learned something from this?
Yes, ma'am.
What have you learned?
Not to ever do this again. Put my hands on an officer, get in an altercation.
And let's see how much you've learned. When I drug test you today, what are the results going to be? Because that'll show me if you learned something.
From probably dirty from like the past month because it takes a while to get out of your system.
No, it's this happened on or about November 16, 2024. And if you learned something from that night, you still wouldn't be doing drugs. So are you telling me this is some new form of marijuana that stays in your system like close to a year?
No, he meant to say that he probably smoked like a month ago.
Yeah. So he didn't learn anything from this because a month ago, we're in October. So a month ago, it to put us in September of 2025. So you have learned nothing. Who do you live with?
My tia.
All right. So what, your mom put you out or did your mom's new husband put you out?
No, ma'am. I moved over there because it's closer towards the city. She stays more like far west side, Helotes area.
I don't know if he's going to do well on probation. And let me just tell you why. I don't think he's learned anything from that night. He's still doing marijuana. I'm going to follow your agreement. I'm just telling you the tea leaves are saying that he's not going to do well. And his mom is not helping because everybody wants to be everybody's best friend. I don't know what happened. I don't know what's happening at his tia's house. I don't know. Is your tia allowing you to do drugs at her house?
No.
Then where are you doing drugs?
2.5 free time.
And where would this be?
3 hours during the day I have to myself when I get away from people.
Yeah, but where are you when you're doing drugs?
Outside.
See, he needs structure. He doesn't have it. I can't give him structure other than tightening up his conditions of probation, but I don't know if he's going to do well on probation.
We've discussed that, Judge, in my office and the days that we've been in court, and he assures us that he's going to stay away from marijuana because I told him you can't be doing marijuana or anything
I
like
can't
that.
mess up. Yeah.
I made that abundantly clear, Judge.
Oh, I'm so sorry. I don't have his, this is the wrong, trial court certification. Okay. So I need the other one from over there.
Okay. We'll get it, Judge.
Okay. All right. Oh, you can go ahead and get it. Thank you. All right, probation. This is what I'm going to do. Sentence him to 8 years in the prison, suspended and probated for 8 years. There's a $2,000 fine. That will be probated. Do you have any children?
No, ma'am.
Okay, that's a good thing. You're not ready. There's going to be regular reporting by Zoom or in person, regular random UAs, tests for levels, field visits 1 time per month until further notice. There's to be no contact with Ethan Durand. 200 hours of community service restitution. Those hours will be deemed satisfied if he obtains his GED or some type of trade school certification. The court will note that the restitution has been paid in full.
Judge, there was,
Oh, there's some more restitution.
well, we left it that if there was less, it was okay, but if it was happened to be more, that the victim would document with probation, and my client is willing to agree that if there was something else that he could pay it, Judge.
All right. Can I have a restitution hearing in 30 days, please? All right, state,
Yes.
by November 10th, let us know if there's any restitution.
And the attorney that's out, ADA, she was working on that, but she wasn't in court today to give us a response. She might already have that answer.
Okay.
But she was calling in from court the last time we were in court last Thursday.
Okay. Probation, is there anything else? Thank you. Proof of employment within 35 days. no employment as a home health care provider or with minors. And there's to be no residing with minors. Is there anything else you need to be successful?
No, Judge, thank you, Judge.
You're welcome. Did you review the document entitled Trial Court Certification of Defendant's Rights to Appeal with your attorney? Did you understand it and sign it? Because this is a plea bargain agreement, because I followed your plea bargain agreement, and because you waive your right to appeal, you do not have the court's permission to appeal. Because this is a felony conviction, you're not allowed to own or possess any weapons or ammunition. If you have a question of what a weapon or ammunition is, you'll need to speak to an attorney. Do you understand?
Yes, ma'am.
All right, we can go off the record. Here's the thing. I hope you do well on probation, because if you do not, you're looking at potentially 8 years in the prison. Do you understand?
Yes, ma'am.
So if you're trying to make a decision, is this something I should do or not? If it's going to result in you having a motion to revoke, don't do it. If you think, oh, well, maybe, or maybe they'll catch me, maybe they won't catch me doing this, don't do it. Because your attorney will tell you, I take no pleasure in sending anyone to prison, but if it's warranted, I will. You understand?
Yes, ma'am.
Now, I don't know what's happening with your mom. I don't know why your mom allowed you to drop out at 10th grade. I don't know why your mom allows you to smoke marijuana at her wedding. I don't know what's going on in your household, but obviously you're going to have to be your best friend. And as your own best friend, you're supposed to want what's best for you. And what's best for you is to complete this probation and start using marijuana, because you don't know what's in it. And it's going to result in your being revoked. You understand?
Yes, ma'am.
All right, good luck to you. Thanks,
That
Kat.
be excuse you.
Yes, good seeing you.
Same here.
Thank you.
You're welcome.
You said